All right, ladies and gentlemen, I am Professor Brenton Boyce, and I'm about to discuss Chapter 11 of our textbook, Winning Courtroom Testimony for Law Enforcement Officers, The Law, Art, and Science of Effective Court Communication by Matthew J. Medina. So we're going to discuss Chapter 11. Chapter 11 is actually the first chapter that takes us into the final section, Section 3 of the textbook. So the textbook is actually broken down into three sections, and Section 3 is when we're finally talking about cross-examination. So the last three chapters, 11, 12, and 13 of the textbook, are about cross-examination. So simply just talking about what to essentially expect, and how the process of cross-examination is supposed to go, and essentially why it's even in place. So, of course, with cross-examination is something that is protected in the Constitution. It is in the Sixth Amendment, the right to confront witnesses against you. That is a constitutional right. If someone is going to accuse you of something, then you have the right to make them face you in court, and to be able to then ask them questions about what they're saying you did and whether or not it's true. So that's an American right. Based upon the Constitution. So that's the main document that created the need and created cross-examination, or what I'll call confrontation. So the main objectives for cross-examination, we're going to talk about how it goes, how the question is supposed to be asked, and why. What are some reasons that or strategies used in cross-examination? Of course, cross-examination, and even the book talks about it. That's that part we see, the best part of all these movies, like My Cousin Vinny, or A Time to Kill, or any episode of Matlock or Perry Mason, when they get to question the opposing witness, and they essentially question them and get them caught up in lies and get them to say, okay, I did it. And even this book says that doesn't, and I'll tell you, as a practicing attorney, that doesn't happen in real life. We don't have that smoking gun moment where the real criminal comes forward because we're questioning them so roughly, and we get them to admit it and they crack under pressure. That very seldom, if at all, happens in real life. It just is what it is. So when you see the Matlocks and the Perry Masons, of course, they always make it look good, right? Cross-examination, you get that person to crumble. But for the most part, it doesn't work like that. It's not very theatrical. It's actually kind of boring. Let's talk about it. At its most basic level, cross-examination is nothing more than a way of asking questions. Attorneys are permitted to ask leading questions, and I talked about that in a couple chapters ago. But leading questions are questions that suggest the answer within the question itself. Example, isn't it true that you had on I asked a regular direct question. Professor Boyce, did you have on a red Adidas shirt while you were recording your lecture? It's a yes or no direct question. Yes, no. I can ask that same question, but I'll ask it in a leading way. Here goes. Mr. Boyce, isn't it true that you had on a red Adidas shirt during your recorded lecture? So you see how I'm pushing it. Isn't it true? Or you had on a red shirt, didn't you? So that's pushing you into or pushing the person the question is directed to into an answer. So that's simply what a leading question is. And that there are other ways to ask leading questions, but normally it's either isn't it true or you did this, didn't you? So there are different ways to ask leading questions, but they're questions that suggest the answer to the question and suggest the desired answer in the question itself. So it's almost like you're trying to push the person to answer the question. Now, the thing about a direct question and a leading question, they can both be yes or no questions, right? As a matter of fact, with leading questions, you will prefer that yes or no answer, preferably the yes. when you're on cross-examination, because you remember you're in cross-examination, the litigant is now questioning an opposing witness. So if you can get that opposing witness eating out of your hand and saying yes to everything during your cross-examination, that's a good thing. So you want more yeses here and there. You want to know, but you want to kind of put what I say. You want to add your own kind of think of the word emotional reason for the no, or give the response. And that happened. Did that not happen, or it didn't happen? Did it? No. So you kind of want it's all with the. I'm talking about the questioner, the cross examiner. Kind of have to change their voice and let the jury know this person's giving me yeses, but I want to know here. But we're not going to talk about a whole lot about how to be a litigant, because that's not what this class is about. But we are going to talk about the litigant's tactics in cross-examination. All right. It is a very important part of our adversarial system. As I said before, it's part of essentially the Sixth Amendment allows you the opportunity to cross-examine, to face and cross-examine witnesses against you. But let us not fool. It is important, but don't be fooled. There is nothing magic about cross-examination. It doesn't work like the movies. It's not glamorous. You're normally not going to get that aha moment, or that person to say, okay, I did it. It wasn't a defendant. That's only in the movies. Even the best cross-examiners are unlikely to ever get someone to break down on the witness stand like they do in the movies and TV. So it just normally doesn't happen. So let's talk about the rules of evidence regarding cross-examination. Federal Rules of Evidence, Rule 611. That's what the book talks about. So we talk about federal rules of evidence, kind of overarching, but in most state rules of evidence have the same rules in them, because trial is kind of what trial is everywhere in America. You want it to be fair. Sometimes you have some distinctions, but for the most part, as a matter of fact, in a lot of jurisdictions, the numbering of the numbering of the rules is sometimes the same. So sometimes this is Rule 611 in the federal rules of evidence, and it may be 611 in the state, in some states' rules of evidence. So Rule 611 of the Federal Rules of Evidence, even though Rule 11 A governs cross-examination, not the express subject. Well, I'm sorry. Even though Rule 611 governs cross-examination, the author of this book thinks it's important to learn and often not to fear cross-examination. So don't be afraid of being questioned by the other person. So this is kind of what this is about, kind of teaching you up on why they do it and what their tactics may be. We're going to read out kind of Rule 611 in its entirety. First, 611A, controlled by the court. The court, and then when we say the court, that means the judge. The court shall exercise reasonable control over the mode and order of interrogating witnesses and presenting evidence so as to, 1, make the interrogation and presentation effective for the ascertainment of the truth, 2, avoid needless consumption of time, and 3, protect witnesses from harassment or undue embarrassment. 611B, scope of cross-examination. Cross-examination should be limited to the subject matter of the direct examination and matters affecting the credibility of the witness. The court may, in the exercise of discretion, permit inquiry into additional matters as if on direct examination. So for the most part, that whole scope thing with cross-examination, most courts don't necessarily follow that. They essentially let you just cross-examine the person. Of course, the overarching rule is relevant. So whatever question you're asking, that a litigant's asking in a witness, it has to be relevant to the case. So as long as it's relevant to the case, normally courts are going to let that question be asked. So on cross-examination. So it's not necessarily limited to just what they talked about in direct examination. So, with So the thing about it is, the DAs don't get to control what you, or the opposing party doesn't get to control what you're gonna add, what you get to ask, and what you not don't get to ask based upon what doors they open up. So on direct examination, on cross examination, you're generally not limited by anything except the rule of relevance. Um, Now, of course, sometimes in trial you have there'll be a direct examination. Then it may be my turn, and I'll cross examine this person, and I cross examine them, and then there may be a redirect where the DA gets to come back up and ask him again after I cross-examine them. In that situation, that redirect is going to be limited. So the more times you get to question a person, so when you come up to kind of rebuttal, to give a line of rebuttal questioning, you're usually going to be limited to only the questions that are already, only the subject matter of what was asked, what was just asked, or what's already been asked. So the same roles for cross-examination. If we do a direct examination, then a cross-examination, then they want to come back and do a rebuttal direct examination to what we call rehabilitate their witness after their witness might have been caught up, try to help bring them back. They can do that, and then we can do what we call a recross. But every time we do a is the scope of the questions we can ask gets more limited. So it becomes limited to just what it was only the questions that have just been asked in that in the immediate prior or the prior immediate what I say, I think this is prior immediate line of questioning. So leading questions. Leading questions should not be used on direct examination of a witness except as may be necessary to develop the witness's testimony. Ordinarily, leading questions should be permitted on cross-examination. When a party calls a hostile witness, an adverse party, or a witness identified as an adverse party, interrogation may be by leading questions. So those are some of the exceptions I gave y'all to the leading questions rule. So of course, in general, leading questions are not to be used on direct examination, but however, can be used on cross-examination. If they're ever going to be used on direct examination, it must fall within some exception to that rule. So that's usually when a person's a hostile witness, or you're calling an adversarial witness, a witness from the other side. You want to question them yourself. So normally that's when you get to do leading questions. So recognizing cross-examination objectives. Good cross-examiners will often begin their questions by asking you to admit certain facts that both sides agree with, and this is a tactic. As a litigant, I want to start with the easy questions, the questions we all know the answers to. The questions this person can't lie about, because we all essentially believe in the truth of these questions, and we all agree. So you ask those questions. Now, there are a couple reasons to ask those questions. Let me see. So some attorneys do it, and I prefer to do it because it gets the cross examination. If I'm nicer and I'm asking easier questions, I get to kind of set the tone. I would rather set the tone of being approachable and not badgering the witness. So I want the witness to think, oh, this guy's cool. He's just here to do a job. So, kind of be pleasant and ask those questions that we all know the answer to. They're what we call uncontroverted questions, meaning they're not in controversy, meaning we all agree on those. So you ask those questions to get yeses. And that's what litigants normally do. So you want to get yeses, and you want to kind of build a rapport with the witness as a litigant. Another good thing about getting yeses is you won't, during cross-examination, the litigant that's cross-examining you wants you to say yes as much as possible. Matter of fact, they want to rattle off 8 to 10 questions where your answer is yes. Then it is kind of a trickery thing and a good tactic. Then you throw in a question that's a little bit harder, and you have a rhythm, and you might be able to get them to say yes at that point as well without even noticing it sometimes. In that situation, now if it's it may be a question that they answer yes to that helps you out. or it may help you impeach them later on to say, well, you just said yes here. Now, will they get to explain themselves? Yes, but you kind of can't undo that damage. So now they don't look as credible in front of a jury. Um, so yeah, that's when we use it as a setup question. So that's why it's important, because you're going to have a opposing counsel that's going to be cross-examining you to know your stuff and to know the truth. Even the book says, has it in the bold, tell the truth is easier to memorize because it is what happened. You don't have to fabricate some story and remember the story you were trying to tell, if you're just up there telling the truth. Now, the short review of cross questions. Questions asked by attorneys are not evidence. So questions are not evidence, but the answers to questions are. So a lot of times as attorneys, the one mistake we don't want to make is getting too hostile, to the point where now the jury is focused on the litigant as opposed to the witness on the stand that's answering the litigant's questions. So as a matter of fact, as a litigant, you almost don't even want you want the jury to hear what's coming out of your mouth, but you want them to then focus their attention to the answer of what came out of your mouth. So that's important. Let me see. So even though questions are not evidence, this does not stop cross-examiners from trying to make points with the jury with their questions alone. Sometimes we ask questions even if they're improper and they're going to get objected to. If we can ask the question and get the person to give an answer beforehand, before being objected to, then it helps us at least make a point. Because I think the book says you can't unring the bell. Like once it's happened and once it comes out of your mouth and everyone hears it, even if the judge says disregard that answer, do you really think it's going to be disregarded? No. They also tell lawyers never to ask a question you do not know the answer to. So definitely on cross-examination, you don't want to be out here not knowing what happened and what this person's supposed to be saying. So that's a tip for attorneys. Often attorneys will ask a question simply for the purpose of having the juror hear the question. In other words, the attorney asking the question doesn't care what the answer is. Even if the question turns out to be improper or otherwise struck from the record, the jury already heard the question. And, like you said, they can't unhear it and you can't unring the bell. So now we're going to talk about typical cross-examination topics and tactics, like why they ask you the question. And we call this theory, kind of the theory of your cross-examination, the theory of the case. Now, remember we talked about theory of the case being the cake you're making, and you want to serve that theory to the jury through witness testimony to see if the jury will like your cake and rule in your favor. So typically this is, this part I'm about to talk about is nothing more than the strategy, how you want to ask questions to get your theory out, even if it's on cross-examination. So the first, there's the support defense theory, or what they call, I should have called you as a witness cross. That's when we ask questions, and we know that the answer that the opposing witness is going to give is going to help us or is going to further our case. That's why they call it support defense theory, because they essentially what they're saying supports our case. They also call it I should have called you as my witness cross. So sometimes you're asking questions to reiterate something or to help build your case, but you're asking the question from an opposing witness. Number two, that you are ignorant of certain important facts. So especially in law enforcement, you're going to be testifying to certain things. The opposing party is going to get up there and sprout off a whole bunch of facts, whether they be relevant or not, and they want to get you looking like you don't know what you're talking about. They want to discredit you. And sometimes talking too much you can discredit yourself, or getting caught in a lie. That's the ultimate form of being discredited. Let me see. And then another thing with that is we ask you stuff that we know that you wouldn't know. So I think the book said, here's a question from the book. You testified that you witnessed my client running from the alley holding a gun, correct? And they'll say correct. But you never actually saw my client shoot the gun. Is that correct? Correct. So sometimes you have to get them to admit what they didn't see, or just something in facts. Like, I'm only testifying to what I saw here. I don't have anything to do with that. So doing that, automatically the person may be getting truthful testimony out there, but it's limited to that. They can't, at that point. I mean, the court wouldn't believe them if they said anything else further than whatever their interaction was with the defendant that day. Let me see. Number 3, that you are uncertain about important facts. So they want to catch you up. The opposing party is going to try to get you caught up on stuff that's something, for the most part, not important. But they know you didn't witness something and you're kind of testifying to it, so they want to get uncertainty out early. An example would be, you said the robbery took place at approximately 1 a.m. Isn't that correct? But you were staring at the clock. So you were staring at the clock at the time of the robbery, right? The robbery could have taken place at 1:30 or 2 a.m. then. So like that second question, you were staring at the clock at the time of the robbery, right? If your answer is no, like, no, I wasn't looking at it, then the next question is going to be, so you wouldn't know exactly what time the robbery took place, would you? So that's kind of just to show that you don't know everything in the case. So they're trying to chip away at your credibility. Number 4, sometimes cross-examination is also used to show that you are biased. And not so. There's nothing wrong with being biased in general. Of course, if you are a police officer, you showed up for work today to testify to what happened, and you're hoping that this person you arrested is gonna get sentenced for it. Going to be held accountable. So there's nothing wrong with that, but it is something wrong when that bias is definitely, when it's an improper bias, or it's a bias that causes you to do improper things. Improper bias, of course, is bad. Bias is improper when it rests on relative facts. Improper bias clouds your judgment in a way that causes you to overemphasize irrelevant facts under the bias. For example, or when the biases are improper or irrelevant. I'm sorry, I read that wrong. Let me read it over again. Improper bias clouds your judgment in a way that causes you to overemphasize irrelevant facts or underemphasize relevant facts. So, in other words, if I can prove that you're biased, you don't like this person because of race or whatever, if I can, that's going to make anything you say after that point kind of unbelievable because you're obviously biased. Improper bias makes you an unreliable witness. So, of course, that means you can always, that means a good attorney can come up and say, well, he's only saying this not because it's true, but because he doesn't like my client because my client's black. Simple as that. They talk about some improper biases, of course, racial. Improper bias can also include where a conflict of interest may arise. Like, you're testifying in a trial, and the outcome of the trial will determine how much you get paid, or it helps you out. So it would be improper. It would be a conflict of interest for you to testify in that situation if you stand to gain from the trial, from the outcome of the trial. So most times the attorneys know that, and this is just definitely, I'm trying to think. Most expert witnesses don't testify on a contingency basis. They get paid up front and they got their money. But I'm trying to think a situation where that would be, where that bias will be obvious. Can't think of one now. I'll see if I can come back to one. I think the one I did think of was a bad example. So number 5, that you have some motive or to lie or exaggerate. So they call it the pants on fire. Liar, liar, pants on fire. What do you call it? Theory. cross-examination theory. So they're essentially, talking about what interest you have and why you have a dog in the fight to tell a lie, and then sometimes what that lie is. Then 6, to confront you with your own statements. So as I said before, you're going to be writing narratives, especially as law enforcement officers. You don't just arrest people and go home. I'm done. I'm going to the next. No, you going to the next beat. No, you don't do that. You then, after you arrest the person, now you have to sit there and type a report. The good thing about that is that report is in stone. It's going to be turned in. It's going to be submitted, or submitted to higher ups and almost time stamped. The problem is, if anything you said in that statement is wrong, it's eventually going to come out. So, especially in questioning, you're going to be questioned, and they're going to ask again. You're going to say something different, and then they're going to be able to pull the document and impeach you with it. So you said he was going 80 miles, correct? All right. So read this paper. And is this your handwriting? Did you fill it out? Or when it says how fast the defendant was driving, did you not put right here on this line that the defendant was driving 70 miles an hour? Yes. So at that point, I say no further questions, and I can harp on the fact that this guy has lied on my client. Literally, so he said the day of it was 70 miles per hour, and what are we going to trust? What he's saying today, which is a year removed, or what he's saying and he saw that day of? So that's why we impeach. We want to catch people in prior inconsistent statements. Of course, also, also a good thing is to point out what's not in the report or what they've omitted. It kind of made the cops look lazy or incompetent, that they didn't do something that essentially they can't be trusted, or my client's on the hook for this because they didn't do their job and they want to take down somebody. Then number 7, what can you clearly have done but did not do? That's another thing where you're accusing the officers of being kind of derelict of duty. So where were you at? Weren't you supposed to be here? You weren't there. So all that stuff is stuff that comes back on the officer. And when officers testify in a trial, it may not look good in front of a jury that this person said this on this day and it said something opposite on the other day. So now all the defense attorney has to say is he's a liar, and you pretty much are a liar. Okay, we're going to talk about some other ones. Completely unnecessary test accuracy. Let me see. An example would be a question that says, you testified that you observed my client leaving the store without paying for the item, correct? You arrested him outside the store. Why didn't you take a DA sample? He was right there. He should have consented. So it's all about kind of trying to catch them catch them looking incompetent, so that you can now chip away at that. So, like I said, let me say it in better. It's the prosecution's case to set up. It's the defense's case to look at what they have and don't have and chip away at that icing on the cake and start eating it, because this ain't your cake no more, player. We got you. Let me see. Then we have challenge, when they want to challenge your sobriety. At the time you made relevant observations, so they're always going to ask cross-examination questions that may question your perception, whether you were in a position to see it. And normally I show a clip from my cousin Vinny, but I think I will, where this woman, first this man was being impeached, and he swore that these guys were the guys that robbed and killed this guy in the liquor store. But my cousin Vinny looks at photographs of his house, gets the guy to qualify it or stand by the fact, oh yeah, that's my house, those are my screens, that's my front yard, and that's the window, and that's the window I was looking out of. Now, so this picture's taken from that window, right? What is that big thing in the way of you in the store? It's a tree, and that tree has leaves on. So in other words, he was trying to say something was in his way where he couldn't 100% see what happened. There's the other situation where one was asked if she had her glasses on that day, and she had some thick Coke bottle glasses, so she couldn't see without them. But she wanted to say she witnessed the whole murder across the street. Um, so you can also, you know, be cross-examined based upon that. Then your sobriety, if you were drinking, isn't it true that you were just leaving the bar and you had a couple drinks? So technically, you're not. I guess what's the word? You're not legally intoxicated, at least to drive, until you're at a .08 or higher. But in real life, they always say don't drink and drive. The law is not to drink and drive. It's not to be drunk while driving. So not to drink over, drink over and above the amount that intoxicates you, and then drive. Um, so a lot of times, even though that's the case, sometimes just you having one beer can be something that the opposing side will take all the way to the end. He said he had a beer. He was drunk. So we can't trust what he said. So sometimes they like to challenge your sobriety on cross examination, get you locked in on some things. Your testimony is inconsistent with the testimony of other witnesses. That's another way. So if everyone else, let's say if there are multiple witnesses here that are going to testify, or they have testified to what happened, and they're all saying it one way, and you're the only one in court that says it differently, then it's like, so all these other people are lying. What happened? So you have to think confusion is good for the defense. If I'm defending my client and the prosecution is presenting the case and there's confusion in the case and there's uncertainty in the case, that's what I like. I like for stuff to be, we as defense attorneys, we like for the prosecutor's case to be everywhere, and kind of, be like they're throwing crap against the wall to see what stays or what sticks and what doesn't. So let me see. So yeah, so sometimes when it's definitely confusion if 3 or 4 other witnesses are saying this happened and the fifth witness they call on their end says something different. So then in cross-examination, I can ask him about that. This person said it was this way. Is that true? That isn't true, isn't it? It actually happened this way. So you can lock that person in, and remember the DA may have multiple people trying to build their case. Now, one of those multiple people is lying, or more than one, depending on what side they're on. They're lying. So that creates that reasonable doubt. Don't believe them, jury. Don't believe anything they say. It's all rubbish. Then, of course, if you're an expert, or even in law enforcement, sometimes your credibility can be challenged. They ask you questions about where you got your degree and stuff like that, and something you should have done that was, based upon the standard operating procedures that you didn't do. Did you know about that? So what they want to make you look incompetent. So chapter 11, and I think I said chapter 10 at the beginning. This is chapter 11. Chapter 11 in review. The confrontation clause provides that in all criminal prosecutions, the accused shall enjoy the right to be confronted with the witnesses against him or her. At its most basic level, cross-examination is simply a way of asking questions. Attorneys are permitted to ask leading questions on cross-examination. The judge presiding over the trial has the duty to limit cross-examination to avoid needless consumption of time. 5, the judge also has the duty to protect witnesses from harassment or undue embarrassment. 6, good cross-examiners will have you admit to uncontested facts. They want you to say things that we all know are true. You might want to, what color? The sky's blue, right? There's going to be a yes, so we can go from there. So that's how that works. Remember, questions are not evidence, but the answers to questions are. But even though questions are technically not evidence, a lot of times litigants are going to use their questions to take stabs at the other side's case and to get to kind of sneak stuff or backdoor evidence or testimony into the ears and the perception. The perception of the DA. They wanted to walk, not DA, but the jury. They want the DA. They want the jury to I'm sorry about that. They want the jury, even if it's not going to be, even if it's going to be objected to, if they can get the jury to hear the question and the answer that they wanted, even though it's going to be objected to, and it may be, the judge may say strike that, please disregard. There's always that saying about, you can't unring a bell. So the jury has already heard it. It is already soaked in. So even though the judge is telling them to disregard it, as human, do you think, based upon human nature, that they're actually going to disregard it? No, they're not. So sometimes we use, even though questions are not evidence, sometimes we use, sometimes the questions are used to try to get things in or try to further our case. Sometimes even when it's not answered. So good attorneys like those slide some some jabs in there to get their case heard. Let's see. Cross-examiner might try to show you are ignorant of important facts. Also that you are biased, that you have some motive or exaggerate or to lie or exaggerate, even if it's monetary motive, like you stand to gain based upon the outcome of the case. Okay, the cross-examiner might confront you with your own allegedly inconsistent statements. So that's why you have to prepare before court. Don't only prepare to know what happened, but prepare to know what you've already said about what happened, because you don't want to get caught up, or you at least want to be prepared to explain why you said it and why what you're saying is different now. That actually happened to me in a trial. It was a DUI trial. I had a cop on the stand, and they have this form they fill out, the DWIR form. It's the form they fill out when they arrest someone, charge them with DUI, and it has a line on the form that says, "Did the defendant have an odor of alcohol about his person?" Now on this form, it wasn't blank. He actually filled it out and he said no, none. So then on the stand, he's testifying and he's saying that my client that the night of smelled like alcohol. So, of course, I said, I had to come up to him. Isn't it standard procedure for you guys to fill out a DWIR form? Yes. Do you recognize what this document is? It's a DWI form. And is this your name on the document? Yes. Is it your handwriting? Did you do this? Yes. Is it certified by your signature here at the bottom? Yes. So you feel, and what's the date of it? And he tells me the date. I said, now this was done the night in question, right after you arrested Mr. Johnson for the DUI, correct? Yes. So let's go down to line 14 where it says, did the defendant have an odor of alcohol about his person? Was your answer not no? I mean, your answer here was no, wasn't it? Yes, it was no. So at that point, what I did there is I actually left that line of questioning and moved on, because he had already said he did, but in front of the jury, I got the jury to see that he didn't. So I could then at the end, I could go back and talk to the jury about how he was inconsistent. So it made him look like a liar. So always know what you've already. So don't just know what the truth is, but also have a good knowledge of what you've already said or committed to writing in your cases. The cross-examiner might try to show that your investigation could have been more thorough. So we like to sometimes defense attorneys like to harp on things that you didn't do, even though they may not be of the utmost importance. Sometimes they're not important at all, but we like to chip away at it because even though it may not have any bearings on guilt or innocence, the fact that you didn't do it, we're trying to essentially weaken the case. So the way I see it is defense attorney, what's that? Prosecutors they hate confusion. Confusion hurts their case. They like their water to be clear so they can see through the bottom, right? Defense attorneys, we like to muddy the waters. We like to confuse things. We like a good confused jury, because a jury that's sitting in the jury box like, what's going on? That's the jury we love, because anytime there's confusion, even if we cause it, we can automatically say it's their fault. It's their bad case that's causing this confusion. It's so inconsistent. That's why my client's not guilty. They can't be, his guilt cannot be proven here beyond a reasonable doubt, because you're confused. You don't know what happened, and they didn't present a case that clearly lets you know what happened. So, in that situation, confusion and muddied waters helps the defense out. And last but not least, the cross examiner might try to challenge your background and credibility. That's always going to happen. Especially if you're coming in as an expert witness of some sort. So if they can show that you've been biased in the past or made mistakes in the past, or they're going to come at your background. So that is chapter 11. So once again, at the end of every chapter, we got to review questions. Flip the book upside down, you get the answers. So that is chapter 11. So do that, and you will be prepared. So without further ado, we'll move on. Take care.